If you have an asylum case pending in immigration court, the government may try to get you deported before you ever even get to tell a judge your story. And the weapon they're using right now is a single, badly filled out form, your asylum application, Form I-589. So here's what's happening. At your master calendar hearing or at your merits hearing, the ICE attorney, the prosecutor, files something called a motion to pretermit. It's a weird word, I know. What it actually means is pretty simple. They're asking the judge to deny your asylum case on the spot, right then and there, before you ever get to present your evidence and tell your story, okay? And the reason they give, well, you didn't fill out the substantive questions on your Form I-589 thoroughly enough. So does this apply to you? Well, if you have a defensive asylum case in immigration court and a hearing coming up, yes, it definitely could. If your asylum case is still with the USCIS Asylum Office, then this specific tactic isn't aimed at you, or at least not right now. But if you're in court, keep watching because this is happening to a lot of people. And some of them even had lawyers helping them with their application. I'm going to tell you exactly why these cases are being thrown out, what to do if you're faced with this issue in the courtroom, and how to head it off before you ever walk in the courtroom. And we're starting right now. I'm Brian Manningham. I used to be an asylum officer with the government, but now, as an asylum lawyer, well, my law firm helps immigrants all over the country to secure their future in America through asylum. All right, let me tell you what's really going on with the Form I-589, which is the asylum application form, right? So most of that form is just like personal background stuff, where you went to school, every address you've lived at for the last 5 years. Pretty easy stuff, right? But then there are the substantive questions, things like why you fear returning to your country, what happened to you, whether you might be subject to a bar to asylum, like for example, the firm resettlement bar. Now, these are yes or no questions, but then depending on your answer, you may be required to explain yourself in narrative form right there in the response box or on the continuation pages to the application. And here's where it falls apart. Most people write almost nothing when they're supposed to write a narrative, maybe a sentence or two. Sometimes they leave it completely blank. Often they'll say something like, "See my attached declaration," figuring that the judge will just read their personal statement instead and thinking that, this declaration will suffice. But I need to be crystal clear about this. That is not enough. And I need you to understand why, because this is the legal mechanism that's sinking people. We've seen far too many people get stunned with a deportation order. Sometimes it's happening at the master calendar hearing, sometimes at the individual hearing, and I don't want that to happen to you. So in deciding this motion, the immigration judge will look only at the four corners of your application and decide whether you've stated a claim that could possibly qualify for asylum. And if the substantive answers on the form itself don't do that, then, well, the judge can grant the motion to pretermit no matter how strong your case actually is. And pointing to your declaration doesn't save you, okay? Because the declaration lives outside of the application form. Now, the answers have to be on the form and they have to have some meat on them, okay? They don't have to be hyper detailed, but they must address the substantive questions that are being asked in a clear and meaningful way. Guys, this rule is harsh. It's painful to see someone with a real legitimate fear lose on a technicality like this. I mean, we're talking about people who genuinely cannot go home. The persecution is real, the danger is real, and it can all come down to a box that just didn't get filled in correctly. That's not justice, that's paperwork beating a person. So when I tell you to take the form seriously, it's because I've seen what happens when people don't do that. By the way, if you want to maximize your chances for asylum success, then please be sure to hit the subscribe button and the bell notification so that you don't miss the insights that I share on this channel. All right, so what do you actually do about this? Well, let's start with the worst case. You're standing in court and the prosecutor makes the motion to pretermit and you weren't really ready for it. So what do? You ask the judge for a continuance. That means you're asking to stop the hearing and have it rescheduled to a future date to give you time to address your deficient asylum application. So you tell the judge you want time to amend your asylum application and file complete substantive responses. Now, if the judge agrees, then yeah, they'll give you a new deadline. And it could be short, like perhaps as tight as maybe just 7 days. So the second you walk out of that courtroom, you've got to call an immigration attorney immediately because writing strong substantive responses fast is not easy, all right? You need a lawyer to get started on this task right away. But here's the thing. You should never let it get that far. The smart move is to amend your application before the hearing ever happens. And this is where it gets tricky, so stay with me. You shouldn't just fill out a brand new I-589 and submit it, because if you do that, the judge may treat it as a brand new application, and a new application has a new filing date. And if that filing date is more than 1 year after you entered the United States, well, you've just handed the prosecutor the 1-year filing deadline as a reason to go after you, and the judge now has a reason to deny you. You'd be solving one problem and potentially creating a bigger one. So how do you amend the application the right way? Well, honestly, there's really no single gold standard here, and immigration judges have their own preferences. Some attorneys prefer to take a copy of the original application form and mark the updates in red, trying to make clear that it's an amendment, not a replacement. Now, other attorneys prefer to file a separate document that just kind of lists each question and the updated, fuller answer, almost like an evidence filing. Talk with your lawyer about which route is preferable in your case, okay? But the common thread, whichever route you take, is this. Make it unmistakable that you're updating and clarifying your existing application, not starting over. It's not a new application. You should say as much explicitly at the top of your filing, okay? So to get it all straight, you almost certainly won't want to file a fresh I-589 because that could reset your filing date. Instead, mark up a copy of the original or file a separate document answering each substantive question more fully, whichever your lawyer decides is best in your particular case. And label this filing clearly as an amendment to what you already filed. Okay, now, I want to be straight with you. Even done perfectly, there's no guarantee that the judge accepts the amendment, and no guarantee that they treat it as an amendment rather than a new filing. But at least at the time that I'm making this video, I do think that seeking to amend a deficient application before your court hearing is advisable, given that the risk of pretermission is significant, and when that happens, it's devastating. Look, don't give up, okay? Because this is exactly the kind of problem you may be able to get ahead of with the right preparation and the right help. If you're in immigration court with a master calendar hearing or an individual hearing on the calendar, and you have any doubt about whether your I-589 answers are strong enough and thorough enough, then treat the answer as no. Assume that they're not, okay? And act now before the prosecutor acts for you. If you're ready to take the next step and get help with your asylum case, please call my office today. That number is 713-909-0401. And remember, we help people all over the country, so it doesn't matter where you live. Call us right now to schedule an asylum strategy session so that we can help you to secure your future in America through Asylum. Again, I'm Brian Manning, and it's truly an honor to serve you in your asylum journey.